Is RERA, or the Real Estate Regulation and Development Act, working for home buyers? Now, this one single act, notified in 2016, was meant to give home buyers the much needed protection against all kinds of frauds, which were rampant in India's real estate industry. Builders running away with money and leaving the project unfinished, endless delays in project delivery, and home buyers paying EMI plus rent for 10, 12, 15 years. Poor quality of the final product, project plans being changed at the whim of the builder, amenities not being delivered, no interest being paid to home buyers on delays, and the list just keeps going on. Let's get real. It's been 9 years since the RERA Act has come into force, and you and I are being told that RERA registered projects are very safe. Go ahead, buy an apartment. Law is on your side. Now, is it really? In 2022, Union Housing and Urban Affairs Minister Hardeep Singh Puri himself criticized certain states for diluting the provisions of RERA, and he also highlighted that these dilutions compromise the Act and the very purpose of protecting home buyers. Mr. Balwinder Kumar, who served as a member of UP RERA until January 2024, spoke openly about the lack of enforcement powers in an interview published in October 2024. He called out RERA's failure to have any control over defiant or rogue builders, and also highlighted that the police and district administration continuously ignore RERA orders. Then Rajinder Kumar, an adjudicating officer at Haryana RERA, he labeled the authority a toothless tiger, and he criticized its lack of enforcement mechanism. The Supreme Court has raised issues of poor protection for homebuyers several times since implementation. And of course, as recently as in March 2025, the Apex Court slammed RERA's performance as disappointing, with Justice Suryakant calling it a rehab center for ex bureaucrats. Now, so when the Ministry of Housing and Urban Affairs, in collaboration with All India Forum for RERA, announces that they're setting up a unified IT platform for all RERAs or state RERAs to bring project information on one platform, we are actually left wondering what's going on. Isn't this another whitewash over real issues? Now, the harsh reality is that RERA simply isn't functioning as it should. Let me qualify. I'm not saying it's not working. I'm saying it clearly isn't the kind of protection one had thought would be possible. Let me introduce you to experts who've been dealing with RERA, presenting before RERA, fighting on behalf of consumers, and of course, have a first hand information of all the gaps which are there in the Act or its implementation of the Act. Anand Murthy, the co founder of Square Arts, he heads their capital market practice and has been steering efforts on customer legal and valuation services for the company. We also have with us Avikshit Moral, partner at SNR Associates. Avikshit's specialty is real estate and, of course, RERA law. He has also seen RERA up close and analyzed every bit of its functioning. Aditya Parolia, partner at PSP Legal Advocate and Solicitors, who fights relentlessly for home buyers' rights, and I'm sure a lot of you know him already. Okay, Anand, I'm going to start with you. I'm looking at the data shared by you. 265 cases are is the number that you've taken to various states RERAs across UP, Maharashtra, Haryana, etc., Karnataka in the last 2 years. The recovery of home buyers' claims from builders has been less than one third. That's the number, just about 28%. 50 plus cases are reserved orders for UP RERA, Karnataka RERA, and Maharera, and pending for more than 7-8 months. 30 plus cases are pending at the stage of execution and recovery of certificates, and 15 plus cases you have approached High Court for non-compliance of RERA orders. So my question is, looking at this stats data, your own experience, what is missing? I mean, where have we gone wrong in giving the home buyers that absolute, let's say, protection that we had aimed?
Thanks, Manisha, for having me on your program. You're right. I think, see, we all welcome from the industry perspective the developers, the brokers, and the home buyers, the financiers, and many other ancillary services in the industry definitely welcome the move of bringing at least a regulatory authority, uh, almost now a decade back. And it's been good that it moved in a sort of a right direction. But what we are seeing is that once you have a law and when you have a appellate to go to approach, the basic premises of any consumer of real estate is that a redressal timeline has to be sort of fixed. Uh, the order, the order execution has to be within a timeline. There also needs to be a process and mechanism to see how fast the recovery of the money or the orders are implemented. What we are seeing is that what is happening is that even after the order is received, which takes anywhere between 7 to a year and a half, depending on which uh, RERA authority you're applying, because there is no standardization, because it's a state law, state governing bodies, people involved, what backgrounds they come from. It is not necessary. Let's be honest. One thing it's very important for me to highlight is that most of the people who are heading these departments are do not know the complete nuances of the businesses how they run in India. They basically look after the complaint, and they basically look after how the complaints are on what pretext, and then they pass the order. So the timeline after the order and after the execution also takes time for it to basically happen. So that's my real worry of the aspect. Then I think the timeline needs to be fixed for any sort of redressal mechanism.
Okay, let me just read out the redressal mechanism which is there, right? What are the timelines? Let the audience understand it, and then we'll come back to you and to the other guests. Now, RERA authority must solve any complaints made by home buyers within 60 days of filing. So 60 days is the time. If unresolved, the buyer can appeal to the RERA appellate tribunal. So that's another important point to remember. And the tribunal must decide the case within 60 days. So we are talking about 120 days at most, which is 4 months. If unsatisfied, buyers can appeal to the High Court within 60 days of the tribunal's order, and the Supreme Court is really the last point of any appeal. Avikshit. So now these are the timelines that we are talking about. What are the timelines that home buyers are facing currently if they do have a problem or a complaint against the developer? There's a breach of contract or delivery delays. What's
Hmm.
happening? Can you give us where are the delays?
So, we have a process in Mumbai, or at least in Maharera, where, I mean, if there is a dispute, they try to solve the matter by way of mediation. So, I mean, on the first date of hearing, I mean, they will suggest that you can go for mediation. The mediation process is a good 6 months to 7 months. Let's say that things don't work out for mediation, then it goes for hearing as per the age of the matter, which will take so at least currently the matters that are getting filed, I am able to get matters for hearing which are almost a year old. So it's a 6 plus 1, which is a 18-month old litigation that we are looking at.
18
Uh,
months? Are we hearing it right? 18
18 months
months
for the
is
first day.
the first appearance. So let's say I have my project is delayed. I have demanded interest from the developer. He's refusing to give interest. I go to RERA. The first hearing I get from RERA is 18 months.
That's right. I mean, anywhere between 13 to 18 months. I mean, it may vary depending on the backlog. But yes, I mean, you're looking at least more than a year before you actually get a serious hearing on your matter.
Hmm. So we
And
are
I'm talking
saying that
about
timeline which was specified in the Act, Avikshit, is simply not happening at all.
it's not Manish. I mean, we also have to look at the number of benches that are available today. I mean, like a city like Bombay, I mean, with the number of litigations that we have, I mean, we should at least have 4 to 5 benches that are hearing matters. But we don't right now. And I mean, it's not that people are not hearing the matters. It's just that the inflow of matter is so high that even if somebody wants to clear the backlog, it's just not humanly possible.
Aditya, to me, what I'm hearing is it's becoming like another judicial system rampant problem which is there across all courts of India.
It
isn't
is,
it?
it is,
I
it
mean,
is, it
there's just
is.
not enough people. They're not trained enough. At least we can't say that for our judicial system, but for RERA, they also don't understand the nuances. Give me your
See,
view in terms of what's going on.
no, it's, right. Aviksha is right. It takes around, I think it takes around 1.5 to 2 years on an average for any RERA matter to get concluded, which is similar timeline which we are seeing in the consumer court. But having said that, you will have to understand where the fault lies. The fault lies in the approach that the governments have taken with this act. So when the RERA came in, it was serving three purposes. The first purpose was this establishment of substantial law between the two parties, that was a developer slash promoter and a lottery, that is a buyer and the builder. The second was that it was also serving a regulatory function, that if there are any regulatory breaches, it takes a suo motu cognizance and sees and looks into it, puts penalty, etc., etc. And the third is what we are discussing today, or the question which has been posed is only on the adjudicating part of it. So the what how was envisaged that there will be automatic implementation of substantial law. That is, if there's a delay, what will be the quantum? All these will be applied automatically. But unfortunately, these issues which were to be applied automatically are also coming towards the dispute resolution and issue. So this the quantum of matters which come to RERA today increases the period of delay. Then you have procedural complexities which are involved, which were to be done away with but have not been done away with. But the question which I think we must ask is that we have similar acts in Singapore and Dubai. Why such kind of delays are not there, despite same kind of problems being there as well? And the answer lies that automatic implementation and the regulatory function, the first two parts of the act, are being discharged by the authority very well, in a very well synchronized manner.
I think you really brought about a very important point, that the regulation part of it, whether you're able to regulate the industry to deliver what they promise to the home buyer. If you become lax there, then there is a huge issue. Our intention is not to slam a builder or a developer, it's really to highlight that what home buyers believe in terms of complete protection or a very high level of protection is simply missing. And the pain points for a home buyer struggling under RERA are actually quite a few.
We don't have to go very far away. I am the best sitting example here. I can talk about myself, and
Okay.
5 years I took to get my money back from a reputed developer. But before that, what is also important when we are saying about the consumer experience? See, the three things why the RERA was set up was very simple. That the developer, when he is getting a RERA number or a project approved, he should deliver within a specific timeline, right? And that timeline is decided by the developer based on the quantum of the development and the project nuances between phases. If you have bigger projects, 1 2 3 phases, and he has different timelines why he can start selling it together, right? So it is decided by him. I think
Mhm.
99% cases, RERA authority are giving extension in the name of anything to these developers. I think that's the biggest problem, because you have a regulation. The first demand is to deliver it timely, because most of these guys, most of the developers do not put their own
Anand,
finance.
I'm hearing a number that 90% of the time developers are getting an extension from their self declared deadline for project completion.
Everybody knows that. I don't think any panel member or any consumer or any developer or any authority will challenge it. It's not possible. I mean, so one was because of COVID, they had an extension, which was given in 2020 for further a year. When this thing, which is logical. I mean, I don't mind to take that for 2 years also, because the sales were slumps and things like that. But 99% of the cases, if you see, which are going to complete after the extension, they're all getting 1 or 2 extension based on some factors, because most of the developers keep on saying that, hey, the markets are slow, the sales are not happening, and hence I'm
For
not able to.
last two
Not
years, markets are slow. If there's any developer or builder who's
right.
actually got a RERA extension after 21 saying that markets are slow,
Right.
clearly there is, you know, who's not reading newspapers or seeing sales numbers? So that's a huge question mark for me. Anand,
So that
isn't it
is,
for you as well?
yeah, absolutely. So while your question was related to the consumer kind of a thing, I'm just trying to pinpoint three basic things which RERA is. It's just not, why should on these things, on these accounts, RERA should have an automatic. We are in a digital world. The AI is taking over. The blockchains are taking over. When you know a timeline is this thing and a complaint is registered, the RERA should have the RERA should implement a strategy of saying what is the date, and if this
Correct?
extension time is not there, it should pass an order automatically. Try to see. I mean, there is has to be. I'm saying that the things can be much simpler, right? The second thing is as to how they sell. A developer sell the consumer in 2 3 pretext that I will give you some returns if you buy now. I will give you a subvention which actually was banned by the RBI, right? And third largely is the amenities of the people. Developers launch a project saying that it is a 10-acre project. Once they sell 50% of the area, they cut short the project. They will do JV with somebody else or XYZ, right? So
Mhm.
these are the three big pockets of issues. Largely there are no other issues.
Okay. All right,
Right?
Anand, hold your thought. That's a really good point for me to segue and ask Avikshit some questions. So Avikshit, whether you look at, I mean, everybody, including the Supreme Court, has been saying that one is that there is a backlog of cases. There is a capacity constraint. The bureaucrats who are sitting there probably don't understand the nuances of the business. They're not able to take care of it. So there is a delay in terms of even being able to get a hearing. But once you get a hearing and you spend 2 to 3 years trying to get a order, execution is a huge challenge. I mean, Balvinder Kumar has said it himself. There are people from RERA who have come out and said frustratedly that if we bureaucrats cannot get anything implemented, what chance do private citizens or private home buyers have?
Right.
Avikshit?
So, Manisha, I mean, there is two parts to your, I mean, the question that you raised, there are two parts that I need to break it up to. One is, as far as the order is concerned, there is a machinery, right? Every court needs a machinery to enforce the order. If tomorrow, let's say that the party against whom the order has been passed does not respond to it. There's no machinery as far as RERA is concerned. They are purely dependent on the state government, their revenue machinery to treat it as outstanding revenue dues. And I
Mhm.
mean, it's just probably at the bottom of the entire food chain. Nobody cares about it. That's one. Uh,
Explain to us what is this state machinery. So there's the police. If you pass an order, who else is involved in, let's say, RERA passes an order saying that this builder has to pay penalty to these
hmm,
number of buyers and this is the amount, and it's
hmm,
not getting executed, right? The
hmm.
options are imprisonment, fine, attachment of the developer's property. These are the 3 4 things which RERA specifies. So who will be responsible for getting this implemented?
Okay, so Manisha, a step back here. The moment there is an order that is passed, like Anand was mentioning, there is a 60-day period within which you have to pay the money. Now, what we are seeing, a pattern is people are starting to dispute the quantum. The builder, or let's say the home buyer, will have a different number. The builder will have a different number. They will just wait 60 days, nothing comes about. Then you go for execution. There is an execution order that is passed. Then that money that is due becomes equivalent to revenue dues for government. Let's say how a tehsildar or a talati would recover money dues at the land level. This money also has to be recovered by a government revenue officer from the builder. Now, when
Okay.
he has to do this, for him, RERA orders, at least from my experience, will be at the bottom of the list. He will actually recover the departmental dues first and then recover the revenue dues. Okay. Uh,
Mhm.
on the side of imaginative thinking, is it that there is no ability for the authority to recover the money? I don't think that's a correct statement. I think people have to be imaginative here. RERA, okay, they don't have a body, but RERA is the authority who grants registration. If you find a builder who is repeatedly ignored your orders, cancel, suspend his registration,
Correct.
right? That's one. Second, the sub-registrar who registers all your sale agreement, he's a government machinery, send a notice there. Tell him not to register any further documents of this project till the time we give you any further instructions. Can't that
Correct.
happen? the municipal, the planning authority, they are a government authority. Can't you write to them saying that no further plans will be sanctioned because this guy is already, he's duped so many people. We don't want more people to come in.
Correct.
Things can be done, Manisha. I just think it's a willpower and being imaginative and trying to enforce. I mean, that's all that is required.
Okay, let me, I'm going to come to a very interesting yes and no with Aditya, because he's also sitting in a geography which is plagued the most by defiant developers. What was promised in 2016 Act, whether this has been delivered? Aditya, I'm going to ask only for a yes or no or uncertain answer. This is like a quiz for you, okay?
There
The
cannot
first
be a
is,
yes or no. You want me to? There has to be a lot
all
of.
of you can say yes, no, or whatever, but I want only single. And there is a purpose to doing this, right? Builders must deposit 70% of project funds in an escrow account to prevent fund misuse and ensure project completion. Aditya, is this happening? Builders are depositing 70%?
Only on paper.
Only on paper. Avikshit?
Yes, they are.
They are. Anand?
Only on paper, yeah, I agree.
Only on paper. So there are two experts here who have been taking RERA cases to RERA authorities, who are saying it's on paper. It's not. This was the very basic clause in the RERA Act to protect the home buyer, to say that builder can't run away with your money and he will complete your project. Okay. Now let's go to the other one. If the builder fails to deliver on time, they must compensate buyer with the same interest rate that they charge for late payments. Has that started happening largely, Aditya?
No, nope, not at all.
Okay. Anand?
No, not at all. It is linked to SBLR rate plus 2%. So it's anywhere between 9 and 10%.
But when the builder charges the home buyer, he can go up to 18%. Avikshit, am I right?
15 to 18%.
You can
I
do
mean,
whatever you want.
yeah, he writes that, but Manisha, enforcing such an order is becoming very difficult. I mean, a builder also won't be
Very
able to
difficult.
require.
No, so this is what I'm saying. We are looking at very large issues. But if you go clause by clause, there are so many slips between the cup and the lip. It's unbelievable. Okay. Developers are liable to fix structural defects and poor workmanship for up to 5 years at no extra cost. Has that ever happened, Avikshit?
Ever happened? I don't know, but I mean, generally, I think I'll be very honest with you. That's the last thing that a home buyer even goes to court for.
Okay, so we
They
are
don't
not
even
going to, we're
bother
going to
you.
skip this question. Right now,
Yeah.
this is not a priority. If a
Yes.
project is cancelled or delayed indefinitely, buyers will get a full refund with interest. Where is it happening? Anand?
No, I mean, it's
And
again, I mean, I think whatever anybody's writing, or I mean, I'm surprised that this is the law, first of all. So,
I
I
know what
don't.
is happening.
Here we are we are telling everybody you're protected by RERA. The sectors become transparent and safe, and this is the only country where on paper the home buyer gives us fund first 10%. What home buyers are doing is literally, it is unsecured lending to builders. So therefore these questions are really important. what
But
what
I
we
know
are
where that
doing
is
as home
happening,
buyers is
Manisha.
unsecured
I know
loans
where
to
that is
builders.
happening.
Aditya,
I'm saying I know where that is happening, where automatic refunds are being given.
where?
So it is not out of compulsion of RERA. It is a marketing strategy. So suppose you go to a place like Jewar, where Jewar Airport is coming, and land prices have gone up exponentially, and the projects are delayed for last 10 years. It is better to give a refund at 10% per annum. It will just double the amount where the prices have gone 4 or 5 times high. So
Oh,
now
100%.
buyers have started using this act to their benefit, that they refund your money as go to RERA and say, here is a check, I'm depositing, take your money, go back. Tomorrow I'll sell it for 4 times more.
Yes. So you're saying wherever it's convenient, it's happening.
Yes.
There is a case where construction was so substandard, the slabs fell, police
Hmm.
went and nabbed the builder, and the builder's very happy to bring it down, give refund the home buyers money and tell them go buy something else, because we know exactly why. The prices have gone up 3 to 4%. 3 to 4 times. So
Four
even if he
times.
builds new, he's only in profit. Okay. But in genuine delayed cases, this is not happening. Let me come to the next one. Builders cannot make changes to the sanction plans without buyer consent, two-thirds of buyer consent. Who wants to take this first? Is this happening?
So I think the top
I think
developers.
this.
So that the top developers are now, since we deal with almost every developer in the country, being one of the top brokers. I think the top developers, we are seeing a change in about a year's time.
Okay.
In last 1 year, where there is a rule of about, I think if I'm not wrong, 60 to 70% of consents, or every person who is bought into that project needs to take. So, for example, I know that Lodha, Godrej, Mahindra, all these guys are following those rules. By if there are any changes, they are basically calling the customer, have to give a
Okay.
consent. So there is something happening definitely on there, but largely, it totally depends. I would say 50%
So,
projects are following
so
now.
50-50 good developers, reputed developers are 100% following that rule, trying to follow that rule, but it's still not widely followed as it should be, or 100% followed. Okay, we are not even expecting 100% on
It can be
anything at
easily
all now on
violated.
RERA.
It
Okay,
can be easily violated also, Manisha. You can go and take an approval from the RWA president and then display to DTCP or any regulatory authority that see, we have got the permission. And it is very common in Delhi NCR. We've already brought down 4 or 5 buildings based on such changes. So
hmm.
even big developers are trying their best to do it. So it is not that they are not doing it; they are finding other ways to do it than taking a garb of law that
Find a
CBA
few
taken consent.
people, get few on your
Yes,
side, and go ahead and work with the RWS and make the changes.
and then it's
Very
another
important
battle
point.
of 5 years.
Hmm. Okay, now this is now the area where I actually have seen a lot of gaps, but I'd like your expert opinion. Developers must upload and update the following details on the RERA website: project layout approvals and sanction plans, carpet area and pricing details of each unit, quarterly progress reports, which include construction status, sales and financials, completion timelines and milestones, financial disclosures, including details of the 70% escrow account for fund utilization. Builders are also bound by RERA Act to update project progress every quarter on the RERA website. And of course, failure to update the project details is a fine of up to 5% of the project cost. False information on non-disclosure, license revocation and penalties. Jail term for violations. Builders who fail to comply with RERA orders can face up to 3 years in jail or heavy fines. Avikshit, how much of this is happening? This transparency, this entire thing that we are going to create this single IT platform, bring all the projects from state RERAs and make them all available to home buyers. My question is, who is doing quarterly updates for that transparency, Avikshit? And is it even happening at all, even by the best developers and the most reputed developers?
Correct. So, Manisha, there are two levels of disclosures. One is when you are registering your project. Now, at that point of time, your documents will be subject to major scrutiny because you want a number. You want that registration number so that you can start selling. So people do it at that point of time. Post that, there is this quarterly updates that needs to happen. I mean, nobody's keeping a tab of that. I mean, even if you do it, you do it. If there is a delay, it's fine. Whatever you write, I mean, I don't even know whether somebody reads that because these are all self-declaration. It means nothing. Look, you're trying to save somebody from somebody's ill will, and you're relying on the same person's declaration, the ill will person's declaration, to protect a home buyer. It just doesn't work. Secondly, another very important point: investor education in India is extremely low. The things that you spoke about right now, layout, uh, project FSI, floor plan, how many people understand all this? I mean, you may have all the data. Can you make 2 plus 2 when you read all this data? I mean, that's the basic question. Investor education is so low. Just one very important point. Whenever I bump into a home buyer who comes to me, let's say he wants to file a proceeding, the first question that I ask him, let's say, what's your delay? 5 years. He tells me 5 years delay. I ask him, can you show me the mails that you have written to the builder because of this delay? None. 5 years, these guys have never created any records, evidence. They have been talking to the representative over phone, not even a WhatsApp probably. And that's where you lose the matter. The battle is lost there. You don't have any records. So I
Hmm.
feel investor education is also an important role that RERA has totally missed out. They just don't do anything about it.
My God. And I'm so glad, Avikshit, you've called this out. Why in this country are home buyers so blind? And I know I'm going to get wrapped for saying this, but even today, I find, and again, good times come, everybody forgets, Anand, home buyers are not even reading buyer seller agreements. Are they?
Yes.
Yeah, no, no, no. There is no chance. See, you have to also look at um, a capitalist way of, maybe the solutions lies there. A person who buys his first home, I think in our data suggests that it is 5x of his net worth. Typically, 4 to 5x of his net worth. So if he's buying a crore home, there's nothing less than a crore, 50 lakhs, 60 lakhs, right? The individual or a person is basically have savings to about 2 to 5 to 6 lakhs. When I'm saying a 50 lakh home, and that could be about 10 or 15 lakhs when he is buying a 1 crore home. So he's so overwhelmed to buy that asset that he's putting all his life savings, he's borrowed money from relatives XYZ. What this the state and the central government has to look at. While I second what Abhishek is saying, but I am just trying to also tell everybody is that is his not job. He is always asking, "Are you RERA registered?" He's going and checking online whether you're RERA registered. He's checking online who's the promoter, other nuances he doesn't know because he goes by the brochure. He goes to the
Hmm.
site. He sees there is a project which has a boundary wall, and he's seeing, okay, this is the developer, and it applies to every developer. It could be the top developer, it could be the lowest developer. It is the developer job and the authority's job to ensure that what is being promised as the contract is being delivered to him. I'm talking overall perspective. Now, why do you think?
Well, I mean, these
And
are really two very different points of view, and I would agree with both. Honestly, if you are actually putting that big a lump sum of your life savings, yes, you will depend on the authority, but you also have to do at least some homework, read the basics, ask the basic questions, keep a trail of your communication on email. So I understand. And that's where, Aditya, I have to come to you. This whole blanket confidence that builders are talking about, that the government talks about, that the home buyer has, as Anand rightly said, he's so overwhelmed. He's saying, is RERA registered? And therefore I'm safe. Tell me, I mean, like, really, how much has safety increased since RERA? And let's be fair, we are not here to slam anybody. We are not, do
Hmm.
not want to put down an industry. Nothing will change. People will continue to buy homes because it's a necessity. It's a basic necessity. But if you were to give me a rating and say, okay, Manisha, I would give it 6 out of 10. Things have improved at least 60%. Would you go with that number at least?
See, as you were in 2015, and I don't know why after 10 years of an ad coming into picture, we are still facing teething problems. I will say only 20% things have increased, whereby some people know that there's a body called RERA to which you can go and file a dispute. Only that has been done. Rest of the issues, whether the information modules are there or RERA license number, what all you can check, I think nobody is aware of it. Here is where the RERA was implemented, that there will be a regulatory body who will take suo moto actions, suo moto corrections will be made, automatic implementation of penalties will be there. There will be a standard form, a unified builder buyer agreement. But have we achieved that? The answer remains to be no. Still, for a
Hmm.
small delay penalty, see, RERA authority was for a bigger kind of a dispute which was there, whereby amenities, layout, or such things were to be challenged. Not simple delay penalty and refund. That was you put on an automatic route. And
Correct.
these
And that is
information
what
modules,
Abhishek has said. So much
yes,
of it can be made automatic. There has to be. Okay, gentlemen, I think we've spoken a lot and we could speak for another hour. This is not going to end as a conversation, but it is a critical conversation to have. I'm going to ask all three of you for three things that must be changed to make RERA effective, to just essentially give the home buyers the protection that they need. Let me start with you, Anand. Crisp three things which must be done.
I think my demand is not going to be anything other than what is already passed as a regulation. I think what you actually read out, if the first three things are implemented, we are home. So the redressal time, see, it's the timeline of the project should have been done and certified by somebody of repute to say this is the timeline, and you can have a force majeure clause which can basically say on these accounts there will be X amount of time this thing. So that is one. Second is that what declaration they are doing, whether on title or loan on a particular unit. Now they do see, people need to know that the declaration of the mortgage, which they do on a single piece of paper to say whether loan or not, they do it at the project level. There is no account of which units are blocked or not. So proper demonstration online, which is mortgage, which is not mortgage, with which bank. Third, and last is basically declaration of what is sold, or if it is cancelled or it is under RERA, at least people know, okay, A103 is under RERA and belongs to Anand, right? There is nothing needed. The system will automatically this thing. I'm not even going to complaints. I personally believe in the judicial system of our country. I think I've been well entrenched into this, saying that there is light at the end of the tunnel. But I am not going to go and say, hey, you know what, so many complaints are there, redressal time has to be this, blah, blah, blah. I'm saying if these three things are implemented, we should not see more complaints coming.
Okay, Avikshit, that easy? Or we need more?
I think I'll be a little technical here. I feel that there are two urgent things that needs to be done. One is interdepartmental coordination. That will solve 80 to 90% of your problems. Let's say the municipal authority, if they are seeing an issue with the structure, right, that there is mass FSI violation, he has to go and inform RERA. The people cannot wait for end of 4 years for the default to happen and then pick up things, RERA has to be notified then and there. So these departments, or vice versa, RERA has to inform the municipal department. So between the departments, they will have to start talking. This has to become a law. Secondly, Manisha, one of the biggest problems that India faces today, and RERA will not be successful till you don't address that, is the construction-related laws. There is no building code. RERA says OC as per the local laws, but the local laws are not clear about what OC is. A Mumbai may understand a OC differently. A Delhi may understand OC differently. A tier 3 city may not understand what is a OC.
So you're saying unified building laws across the country?
A uniform building code. When people say a uniform like a OC or these quarterly updates that are coming, what are you updating? Because there is no uniform underlying law.
Yeah,
Till the time you don't have it, I mean, I don't think RERA will succeed. You need to address these two very quickly.
Okay. Aditya? No one's saying that RERA needs more powers to get its orders enforced.
That is first thing on my list. That it needs to have much more execution powers, even if they use not the criminal execution powers, but the powers under Order 21 of the CPC. I think problems will be solved. But this interdepartmental thing that Abhishek said is also very important to be taken into consideration. So they need to have effective execution powers. That is most important. Then the regulatory functions need to be taken into consideration. They need to be given that infrastructure. They don't have the infra. You have to understand it. Till date, states also see a RERA as a court whereby people go for a dispute. That regulatory function of RERA is still not in play. And the third and most important thing is that we need to put emphasis on information being provided to RERA and the uniform builder buyer agreement. There's such a small thing, uniform builder buyer agreement, that will solve a huge number of problems.
Because there you problems, and this has been alerted. There was a committee which was set up in the Ministry of Housing and Urban Affairs. We don't know what's happened. It's kind
Supreme
of no
Court emphasized, nothing happened.
Sorry? Supreme
Court asked the government to set up a committee, but nothing happened. See, this small thing of a builder buyer agreement, a 20-page agreement, we are not able to set eyes on it. If you see Singapore or Dubai, they have a standard form of agreement for ages now. You cannot deviate from that. And it has every clause.
So much to be unpacked. And because of the beauty of digital, we've actually let this conversation be free-flowing. And we hope that the audience will watch it, will understand that why it's important for home buyers themselves to be very vigilant, maintain, com- keep checking on updated, information by builders to see whether the project is ongoing properly, right to RERA if it isn't. There's just so many nuances to it. The powers of RERA, they need to be increased. The capacity of RERA needs to be increased. We need to have digital, pervasiveness of information. My God, the list is endless. But gentlemen, thank you very much for joining me today and giving me these insights with your first-hand experience of fighting RERA cases.
Thank you.
Thank you, Manisha. Thank you. To a pleasure.
Let me conclude with my take on RERA and the proposed unified platform for RERA collating information, which the Ministry of Housing and Urban Affairs is working on currently. There are 5 critical problems that the IT upgrade or single website isn't going to fix. Number 1, we've understood RERA lacks enforcement teeth. RERA can issue orders, but it can't enforce them. It depends on state agencies, police, district collectors and revenue officers to act, leading to massive delays. Now, without direct enforcement powers, RERA's rulings are often absolutely meaningless. Let's look at judicial delays and legal loopholes. Cases drag on for 12 to 18 months before even reaching a hearing. Builders, meanwhile, exploit parallel legal routes like NCLT to stall action. Now, if RERA can't cut through the legal red tape, its ability to protect home buyers is severely compromised. Then there are institutional deficiencies. Most RERA bodies are understaffed, as our experts spoke about, handling 80 to 100 new cases daily. Worse, over 60% of RERA officials are retired bureaucrats with no specialized legal training or understanding of real estate nuances. Without an increase in qualified adjudicators and dedicated benches, justice for home buyers will remain slow and ineffective. There are also legal limitations and there's weak recovery mechanism. RERA can penalize builders, but it has no control over their assets. Recovering dues or attaching properties depends on state machinery, leading to years of inaction. I mean, Maharashtra alone has hundreds of unexecuted recovery warrants. A digital platform won't fix RERA's inability to ensure financial accountability. And of course, we all know this conflict of interest. State governments often lean towards protecting developers over home buyers. Police routinely ignore RERA-issued warrants against influential builders. If the system protects the powerful over the vulnerable, transparency tools won't bridge this trust gap. So, we are saying a single website is just an IT upgrade or even a window dressing. Yes, the centralized platform might improve access to data, but home buyers need much more than information. They need action. Thank you so much for joining me.